Good mythical afternoon, everybody. This is Mr. Ayala with a video lecture for you. This is Article 3, the Judicial Branch. So, hopefully everyone's ready to go. You got your notes ready. And as always, please make sure that you are both listening and paying attention to the slides as they are presented. So, first things, let's talk about our objective and the benchmark. So our benchmark is to analyze the structure, functions, and processes of the legislative, executive, and judicial branch. So, as a reminder, since this is the third branch that we're going over, it is Article 3 in the U.S. Constitution. Because remember, the Founding Fathers put the Constitution in order of importance. So from their viewpoint, the judicial branch was the one with the least structure embedded. So this one should be a little bit easier for y'all. So the judicial branch really is our nation's court systems. These are where the trials are held. These trials are either criminal or civil. So, for example, if you really like Law and Order, like myself, you probably already know some of these things. So let's continue. So the courts and the judicial branch, their main power is to settle disputes. Either disputes between an individual and a corporation, an individual and a state or the national government, or between the states or the states and the national government itself. So a criminal trial, its purpose is to determine if a law has been broken and if and what should any punishment be. And remember, if it's a federal law, the executive, aka the president, can pardon or commute these sentences. So the judge acts as a referee, and the jury decides the innocence or the guilty plea of the defendant, the person being charged. This is known as a verdict. They also, in some cases, have the right to judge for punishment. So, for example, these juries are guaranteed under the 6th and 7th Amendments, which we will review later. So remember, you have the judge who's the referee. The jury decides the verdict, innocent, guilt, or guilty, and then at times the jury gets to decide on the punishment. From there, we have a civil trial, which is a dispute between individuals and groups to determine if there's a damage that have occurred. So, an example, a person can sue another person. The person who's doing that suing is called the plaintiff, and the person being sued is called the defendant, because the defendant is defending themselves against the said damages that the plaintiff has put in place. For example, let's say someone hits your car and they don't have car insurance. So you can sue them in court to get the damages paid that have been occurred to you by that defendant. Medical bills, damages on the vehicle, that's how that works. And these are civil trials. So from there, we can continue by talking about one of the main powers of the courts, both at the state and federal levels, to interpret the law. So this means that they have to explain if the law works, or how the law works, using the U.S. Constitution or the state law as a rule book. So this goes back to Montesquieu's separation of powers. So that the court system is designed to interpret the laws put into place by the legislative branch and how the executive branch enforces said law. So how does this start? Well, it starts by this concept known as the English common law. And this starts way back under the Magna Carta and the English Bill of Rights, which we've already looked at, and we're going to look at a little bit further later this year. So from there, in 1789, the Supreme Court will be established by the United States Constitution. And the structure is put into place under Article 3. Judicial power of the United States shall be vested in one Supreme Court. But we're going to separate that out a little bit. But let's kind of look at the lower courts, which would be established under the Judiciary Act of 1789, which establishes the federal court system and those lower courts, aka the appellate and appeals and district courts. So Article 3 states in such inferior courts as the Congress may from time to time ordain and establish, aka that the Congress has the right to add more courts if it's needed, which we do. So the federal judicial system. So there's one Supreme Court with 9 members. Make sure you know there are only 9. We have 13 federal circuit courts, aka the appeals or appellate courts, and 94 federal district courts, also known as trial courts. So it's kind of like a pyramid. 1 on the top, 13 in the middle, and 94 on the bottom. We're going to be looking at these later as well. So from here, these are the circuit courts. So the state of Florida, we are in the 11th Circuit Court with Georgia and Alabama as well. So we're going to look at this a little bit more in depth later. So from then, we have what is known as a dual court system in the United States. So we have state courts and federal courts. Those federal courts deal with national concerns, while state courts deal with things in individual states. So for example, if you break a state law, you go to a state court. If you break a federal law, let's say for example, like, I don't know, stealing V-Bucks through a cryptocurrency account, what that will do, that because it goes over state lines, it will be under the federal court's jurisdiction, which we're going to look at as well. So there we go. A jurisdiction, kind of a hard word there, is the power to hear a court case. Original jurisdiction, who is the group that has the power to hear a case first. So, in order, we have so the very first original jurisdiction is usually your district court. Then your appellate jurisdiction, or the ones that come next, are your circuit court of appeals, like how we're in number 11 in Florida. And then if it gets appealed again to a higher court, it goes to the U.S. Supreme Court, which is known as the highest court of the land. And the only way to break a Supreme Court decision is either by the Supreme Court itself revisiting it, or by the United States Congress creating an amendment to change the law, or the Constitution. So, district courts are where the court cases start. We call these trial courts. So they are federal trial courts. This is where cases are tried, witnesses testify, and juries serve on these trials. It's divided into 94 federal judicial districts. So, this is the one that's way on the bottom down here, if you look right here. Let me see if this wants to work. Yay, look, I can draw. Whee! So this is what we're talking about right now. The district courts. So, later we're going to look at the courts of appeals and the Supreme Court as well. So from there, see if I can stop doodling. There we go. We have an appeal or appellate court, which is when you go to a higher court to ask to reverse the decision of a trial court after the final judgment or other legal ruling. See, these are courts that hear appeals from those lower courts. So you have the district courts, which is where it starts. You have the appeal or the appellate court, which goes to the circuit. And then if the circuit courts, if they get an appeal, it goes to the Supreme Court. So the Court of Appeals is if you lose a trial in a district court, you can appeal to a higher level court. And this court will review the case to see if the judge applied the law correctly. And if it is, the judgment stands. If not, it can be reversed. And of course, either the prosecution or the defense, aka the plaintiff and the defendant, have the option to appeal to a higher level as well, known as the Supreme Court. So, but before we get there, at the Court of Appeals, there is no jury or trial. It's usually a 3-judge panel that reviews the trial and makes sure the law was applied correctly. So there's a lot less people involved in this decision-making process. So from there, the Supreme Court. This is the highest court of the land, and it hears cases from U.S. Court of Appeals and state Supreme Courts as well. But first, they need something known as a writ of Cert. I'm so sorry, my Latin's really bad. I just like to call it the Writ of Cert. And more or less what this is a petition that must be filed with the Supreme Court to ask the court to hear the case. It's usually from the appeals courts or the petitioners themselves. So either the plaintiff or defendant can appeal to the Supreme Court using the writ of cert, or the courts, the appellate court at the circuit level, may ask for a writ of cert as well. And they will usually look at them, and you're very, very lucky if the Supreme Court will look at the case. The majority of the cases that they get a writ of cert for are denied. So be aware of that. So the Supreme Court is made out of 9 Supreme Court justices. They are appointed by the president who serve for life. So more or less they're there until they pass, retire, or are impeached. So what are these powers that the Supreme Court has? Well, the federal courts will hear these controversies between 2 or more states, citizens of different states, or ambassadors and maritime, aka on the water. And it's designed to be vague. Like a lot of things in the Constitution, it's designed to be vague unless it's an enumerated or expressed power. So remember that. Enumerated legislative branch is written, expressed, written about the executive branch. So, but the main power comes from the concept of judicial review. So the court gives himself this power from a court case named Marbury v. Madison in 1803. And this is where Chief Justice John Marshall will claim the power to interpret the law. He says that the Supreme Court's main powers implied under Article 3 is to interpret the constitutionality of a law or action. So it can be designed both for a law itself that was designed by Congress, a regulation by the president, aka an action, or between different groups as well. So to get back to our conversation about Marbury v. Madison, Chief Judge Marshall says, it is empathetically the providence and duty of the judicial department to say what the law is. That the judicial branch of the federal government, aka the Supreme Court, has the right to say the constitutionality of a law or action. And if the law or action goes against the Constitution, the Supreme Court can declare this null and void. So, for example, Brown v. Board of Education, 1954. So what happened prior to 1954, in particular in the South, schools were segregated by race. And it goes all the way up to the Supreme Court. And the Supreme Court rules that school segregation is unconstitutional because public schools must be equal for all students, no matter their race. And then when you separate students by race, that is inherently unequal. So the idea of keeping different schools segregated by race was thrown out and shown to be unconstitutional due to its inherent inequality that's embedded in those laws. And as always, don't forget to be awesome.